Discussed many things related to directors, powers of directors we have studied, duties of directors we have studied. Today we are going to specifically discuss the liabilities of directors of public companies. Okay. Number one, liability to the third parties. Who are third parties? Customers, bankers, suppliers, creditors, government, any person who is related to a company in some financial or another interest, he becomes third party. Okay. Under the Companies Amendment Act 2013, number one, prospectus. If there is misstatement in prospectus, there is both types of liability, civil liability as well as criminal liability also. Okay. The most dangerous liability is signing an untrue statement in prospectus. Why? Because prospectus is a mirror. It shows everything about the company to which the investor believes, and if wrong information is given, the investment decision can be wrong in the hands of investor. So criminal liability is also provided for misstatement in prospectus. There is an imprisonment up to 5 years, 3 to 5 years in case of untrue statement in prospectus for directors. Imprisonment means jail, jail means Yerwada jail. Is that clear? So this is very dangerous liability. Second is irregular allotment. Allotment must be done within 1 month from the closing of subscription list. Okay. So within stipulated time, allotment must be done. Otherwise, directors will be liable to third parties. They may claim, they may go to the court of law. Fraudulent trading. What is fraudulent trading? In case of issue of shares, if it is IPO, initial public offer, or FPO, further public offer, there should be transparency. Usually listed companies enlist their shares with the recognized stock exchange, and every sale, transfer of shares, securities goes on through stock exchange, through brokers and sub-brokers. There must be a transparent position. There shall not be an adjustment by the directors or any officials of the company to defraud with the investors. Then liability in case of ultra vires act. What is ultra vires? Ultra means beyond. Is that clear? Ultra, the meaning of the word is what ultra vires is beyond the scope of memorandum. Anything which is not allowed and it is done by the directors, then it is ultra vires. Then such directors will be personally liable if they will go beyond the scope of powers provided to them. For example, in liability clause, it is written in the memorandum of the company, the borrowing power of this board of directors is only 2 crores and directors borrowed 10 crores. Who is wrong? Whose mistake? Directors' mistake. Who is responsible? Directors. Because it is ultra vires act, one which is beyond the scope of memorandum, beyond the powers. Then contractual liability. If directors enter into any contract with third parties, they are personally liable. If the conditions have not been followed properly, then director will be personally liable for the contracts entered into by them. Second is liability to the company. Negligence, number one. If directors are negligent in taking managerial decision making, in that case, for negligence directors are liable. Because in law, every section provisions have been given, time limits have been given. Directors are supposed to have that much knowledge and they shall follow the provisions. Second is misfeasance. Misfeasance means breach of duties. Breach means todna, to break, to unfollow. That is breach. Is that clear? Misfeasance refers to breach of duties. Is that clear? Now it may be willful. Is that clear? If breach of duties is willful or unwillful, that is second part. But if there is misfeasance, directors are personally liable to the company if any wrong decision. Third, ultra vires acts. Again, if directors are going beyond their powers, then they will be personally liable to the company. Same like third party. Breach of trust. Yesterday we discussed. Trust is what? Shareholders, while electing their representatives as directors, they provide a fiduciary position to the directors. And the meaning of the word itself shows trust and confidence. Fiduciary means what? One which creates trust and confidence in somebody. So if there is breach of trust, then definitely directors will be liable to the company. Then Malified Act. Malified is what? Illegal act. Fraudulent Intention Act. Illegality is there in malfunction. That is Malified Act. If directors are involved in any Malified Act, for example, pharmaceutical company is there. The government has provided license to the pharmaceutical company to provide drug to save the life of mankind. And if they started producing cocaine and heroin in pharmaceutical industry, they have some formula of producing cocaine. Is it allowed? No. It is illegal act, Malified Act. Directors will be behind the bars. They will be personally liable for this. Is that clear? Then come to liability for breach of statutory duties. Yesterday we discussed statutory duties. Many statutory duties we have discussed, like preparation of directors' report, annual report, financial report, then financial statements, preparation, presentation into annual general meeting, to convene an annual general meeting. All these are statutory duties. If there is a breach, then directors will be personally liable. They have to follow the dates. Liability for the act of co-directors. See, if co-directors are wrong, but one particular director is right at his position, he will not be liable. He will not be liable with the board. If he proves that I am no way involved in this meeting and decision making, no liability will be there for co-directors acts. But if he fails to prove that, then joint liability may arise with the board of directors. So minutes of the meeting, proceedings of the meeting, agenda, notices, everything is very important in the court of law to prove what was discussed and what was the decision and who were the members present for the meeting. Very important. Then come to criminal liabilities. Criminal involves crime. Number one, failure to repay deposits. Section 73 and 74 subsection 2. 1 crore to 10 crores is the penalty to the company if there is failure on the part of company to repay the deposits. Public companies are given the right to collect deposits from the public. But that agreement contract is written. The clause is always mentioned after how many years, how many months that deposits will be refunded. So company has to refund on a predetermined date. If there is a failure, section 74 subsection 2 will be applied. 1 crore to 10 crores penalty for company and every defaulting officer including directors. Imprisonment up to 7 years. 7 साल की जेल है. सोचो, non-bailable offence it is. And 25 lakhs to 2 crores fine. Fine is given to defaulting officer. 25 lakhs to 2 crores. Then second is untrue statement, misstatement, wrong statement, false statement, fraudulent statement. If it is there in prospectus of the company which was published before the public issue, then 50,000 to 5 lakhs under section 26 penalty is provided and even imprisonment up to 3 to 5 years depending upon the judgment of the court. Clear? Defraud, duplicate share certificates, 50 share certificates provided by the company to defraud with investors. Up to 10 crores fine is provided under section 447. Then failure to lay accounts and financial statements in annual general meeting of shareholders, 50,000 to 5 lakhs is the fine under section 129. So 31st March, balance sheet must be closed. Annual general meeting must be conducted within a period of 365 days, at least once. Compulsory provisions. Is that clear? These are dangerous provisions. Now you may ask me question, why? Friends, the people, if you will see the history of Indian corporate sector, The people who were riding on the tallest horse in the history of Indian companies, they are behind the bars. Many companies like Sahara group of companies you would have heard. It is a very big name, very big work it was done by that company. But even company faced consequences due to the provisions of this. Law is same for everybody. And the major intention of the government is to protect the interest of the shareholders, protect the interest of investors in the country. So to regulate and control the functioning of Indian companies, the machinery like SEBI, Securities Exchange Board of India, had been started by the company, Indian government. In 1992, Securities Exchange Board of India Act was passed by the Parliament of India. Two major goals. Number one, protection of the interest of investors. Number two, to regulate the functions of Indian companies. SEBI is playing leading role in maintaining the interest of investors. Now if you see, remedies for breach of duties by the directors. 5 remedies are there. Number one, injunction. What is injunction? Injunction means court order. Stay order of the court is called as an injunction. Shareholders can go to the court, any aggrieved party can go to the court and they can demand injunction. Process will be stopped, directors will be taken action. Then damages and compensation can be recovered through court from the directors of the company. Third, restoration of company's property. If there is illegal access, illegal transfer, sale of the property without accounting receipts of transfer, such property can be restored with the company. Number 4, remedy number 4, return the profits and gains illegally received by the directors of the company. If it is proved to the court of law or tribunal, tribunal means NCLT, National Company Law Tribunal, it's a government agency. It works under the MCA, Ministry of Corporate Affairs of Government of India. So, all profits can be returned by the directors to the company once it is proved. And lastly, dismissal of directors. The power of dismissing directors of Indian companies lies with NCLT, National Company Law Tribunal. It is a court of companies and it is empowered by MCA, that is Ministry of Company Affairs. So I hope it is understood. If any question is there, you can ask any question, any doubt. That's all.